Hey there, welcome to my channel. In today's discussion, we are going to talk about bankruptcy proceedings. We are going to look at who are the people who are supposed to bring bankruptcy proceedings in court, why should they bring bankruptcy proceedings, the steps or the procedures that normally involve the bankruptcy proceedings. So we're going to start with section 20 of the Insolvency Act, Cap 108. That's the revised edition. It provides for the petition for bankruptcy. When you look, subsection 1 provides for a debtor himself can petition to court applying for bankruptcy proceedings, but here the debtor has to satisfy court that he or she is unable to pay the debts. Whereas when you look at subsection 2, you see that if the debtor fails to fulfill a statutory demand that is stipulated under section 3 of the Insolvency Act, Cap 108, then the creditor can petition to court for bankruptcy proceedings. So in section 20, it shows that both the debtor and the creditor can bring bankruptcy proceedings using the debtor himself and the creditor for failing to fulfill or satisfy the demands of the statutory demand. The statutory demand is provided for under section 3 of the Insolvency Act, whereby it's a demand notice that is issued to the debtor personally. And the contents of this demand notice, it has to show the amount that is owed by the debtor from the creditor. This demand notice is issued from the creditor to the debtor, and according to Regulation 36, it provides for the circumstances where if at all the creditor has failed to serve the demand notice or the statutory demand to the debtor himself, there are other exceptions or other circumstances whereby you can put it at the address. You can take it to the address of the debtor. You can give it to the close relatives or family friends of the debtor, and you can give it to the personal lawyer of the debtor. Those are some of the other circumstances if at all you fail to get the debtor himself. Then what you should note that under statutory demand is that it's issued by the creditor to the debtor, requesting him or her to pay the amount prescribed in that demand notice or in that statutory demand. Then if the debtor fails to satisfy or pay that debt, then the creditor can take or can bring a cause of action in regards to bankruptcy proceedings to court. And this is provided for under section it is section 20 subsection 2 of the Insolvency Act, Cap 108. And now if at all the debtor petitions to court for bankruptcy proceedings, he has to give evidence that he is unable or she is unable to pay the debts. For example, the debtor has to issue to court the statement of affairs. The statement of affairs is provided for under section 21 of the Insolvency Act, Cap 108. Now, in this statement of affairs, it provides for all the property, or it provides for all the details of the property or anything that is valuable that it's in the possession of the debtor. And now it is through that statement of affairs that the court sees and confirms that indeed the debtor is unable to pay the debts. And now this statement of affairs has to be attached, an affidavit has to be attached on that statement of affairs and presented to court. So basically the essence of the statement of affairs as provided for under section 21 of the Insolvency Act, Cap 108, it provides for the details of all the property in possession of the debtor. And remember that for the court to grant a bankruptcy order, it must be satisfied that indeed the debtor can't pay the debts demanded by him or her. And now, after that, public examination has to be made, and this is provided for under Section 22 of the Insolvency Act. It provides that after the statement of affairs has been issued to court, then public examination will proceed. And public examination, this is whereby there is what we call questions, like they ask the data questions in regards with the details of the property that he or she has attached or presented before the court in the statement of affairs. So that the essence of this is that the court wants to know that indeed is it the property of the data. I think that's why it asks questions in public, in court. Are you seeing? So that's the essence of Section 22 of the Insolvency Act. And also don't forget that if at all the property is owned jointly by two parties, for example, if A and B purchased a land at Chitala and they own it jointly, this property can't be considered, or this property can't be considered in bankruptcy proceedings. It's protected against from the creditors, where if at all the creditors are asking questions or want to take possession of the property of the debtor, they can't touch a property that is owned jointly by, that is to say that owned by the debtor and another party. Any property that is owned by the debtor personally, that property can be taken by the creditors. But however, if the property is owned jointly, then this property can't be advanced to bankruptcy proceedings. If the court finally is satisfied now that indeed this person is bankrupt, then the court will appoint an official receiver. This official receiver that is appointed will have powers to sell and dispose of any property, but he or she has to do in the best interest of the creditors, so that the money got from that property has to be taken back and paid back to the creditors. And this is provided for under Section 20, subsection 4 of the Insolvency Act. Now, after the official receiver is appointed by court, the official receiver will call the first meeting with the creditors, and this is provided for under Section 24 of the Insolvency Act. Now, in this meeting, the official receiver will call the creditors to come and attend a meeting on a certain date specified by the official receiver. And all, I repeat, all the creditors will be invited, and a public notice shall be given in a gazette and any newspaper that is on high demand. Information will also be passed there calling the creditors to come in this meeting. Now, after these creditors have come and they have gathered in a meeting, then they shall appoint a trustee. The appointment of the trustee is provided for under Section 25 of the Insolvency Act. Now, after appointing the trustee, then the powers of the official receiver will cease to have effect. Then after the trustee being appointed, he will start performing his or her duties as a trustee officially. And the duties of a trustee are provided for under Section 29 of the Insolvency Act, and these include taking custody of the property of the debtor, selling the property of the seller on the benefit or in the interest of the creditors, and any other duty that is given to him or her by the creditors. Remember, a trustee is like a bridge connecting the debtor with the creditor, and the main duty of the debtor is to make sure that the debts demanded by the debtor is paid and covered fully to the creditors. Are we together? And when you look at Section 31 of the Insolvency Act, Cap 108 provides for the property that can constitute to bankruptcy estate, and this property include the property belonging to the debtor. I think so. This means that any property that debtor has, this property can proceed to the bankruptcy proceedings. This property, the trustee can take control of that property, and if he or she deems fit, he can sell this property and gets the money and pays back the debt to the creditors. And you should also note that tools used during employment, clothing, bedding, and basic necessities, matrimonial home, any property prescribed by court, these other properties do not constitute bankruptcy estate, basically meaning that this property is out of reach of the creditors and trustee. The trustee will not sell or touch or control or take in any way in regards to custody is concerned this property. Why? Because they are prohibited by the Insolvency Act. They cannot be removed or taken away from the debtor. Are we together? That's the matrimonial home, the tools used during employment, the clothing, beddings, or any necessities, or any property that the court has said, no, leave that property. Those properties are protected from the trustees and the creditors. Now, the question will come according the modes of payment. Which creditor is supposed to be paid first? I think now that's another area that you should note. When you look at Section 11 of the Insolvency Act, provides for preferential debts. Preferential debts, these are debts of first priority. For example, the liquidation costs, the allowances, the enumeration and expenses of the liquidator, any other in regards to Section 11. Now, if Section 11, those debts are all paid, then we go to non-preferential debts. Those are the last debts. And it's provided for under Section 12 of the Insolvency Act. Section 12 of the Insolvency Act provides for non-preferential debts. These are debts that are supposed to be paid after paying the preferential debts. So after paying the preferential debts as provided for under Section 11, both in subsection 2, subsection 3, 4, and 5, then you go to non-preferential debts under Section 12 of the Insolvency Act. Then if at all, let me say that the property was sold by, let me say, the trustee, and there is some surplus. That surplus got over that property has to be returned back to the debtor. You should also note that. According to Section 41 of the Insolvency Act, Cap 108, it provides for the termination of bankruptcy. It provides for circumstances whereby bankruptcy proceedings can be terminated. For example, it can be terminated if at all the creditor withdraws the petition. It can also be terminated in instances whereby the bankruptcy order has been annulled. It can also be terminated if at all the statutory demand is set aside, and other more. So read Section 41 of the Insolvency Act. And also another thing that you should note is that after the appointment of a trustee, the creditors can vote a few people in a committee of inspection, and this committee of inspection will oversee the activities of the trustee, and this is provided for under Section 46 of the Insolvency Act, Cap 108. And now this committee of inspection, for it its main purpose, shall oversee all the activities being done by the trustee. And according to section 48 of the Insolvency Act, it provides that the trustee shall declare and distribute the dividends or the payment of debts. And when the trustee has realized all the property of the bankrupt, he must give public notice and personal notice of all known creditors. And this is provided for by section 49 of the Insolvency Act. So meaning that if at all the trustee has sold off the property, he has to give notice to the creditors. So for guidance, read the case of Thomas Kato, that's a bankruptcy petition 2013. So that's all about bankruptcy. So if at all you find this channel helpful, please like, subscribe and share so that your colleagues can also learn and pick something. So thank you very much. See you.